Hello, and thank you for joining me, Steve Howe, for this discussion on the new European Unitary Patent and the Unified Patent Court. This presentation is based on a presentation that I've recently given to US patent attorneys in June 2013 and very much reflects the current status of the Unitary Patent and the Unified Patent Court in Europe. As we get closer to the introduction of the Unitary Patent and the Unified Patent Court, there will clearly be many more features and much more information available, and so certainly come back to me if you need any more information as time progresses. I gave this presentation in the US with one of my partners, Julie Richardson. Julie and I are both partners at Reddie and Grose, based in the Reddie and Grose office in London in the UK. We are both UK and European patent attorneys, and as such we spend most of our professional life in obtaining European and UK patents for our clients. We certainly do get involved in some aspects of litigation, in particular in revocation proceedings before the UK Patent Office and in European opposition and appeal proceedings. However, when it comes to court proceedings, we're very much then part of a team involving a solicitor and a barrister, or perhaps a team of solicitors and barristers, and therefore we don't have as much experience in court proceedings as we do in obtaining patents. Therefore, for most of this presentation, I'm going to concentrate on the Unitary Patent itself rather than the Unified Patent Court. However, the Patent Court is where unitary patents will be enforced, and therefore it's very important to have at least some understanding of the court structure and the court system in which the patents that are obtained as unitary patents will be enforced, and I'll therefore touch on this in a little detail later. So to begin with, I'd like to think about the position for patenting in Europe from the perspective of a patentee and an accused infringer. Now, in many ways, a patentee would think it would be very nice to have a single patent which covered the whole of Europe, to be able to have a single court in which to take actions to enforce that patent, and in fact to have only a single action that they would have to bring for enforcement of that patent, rather than having to take separate actions in individual countries across Europe, as is currently the case. It would also be very nice for a patentee to be able to get a single injunction which covers the whole of Europe, rather than having to obtain and enforce separate injunctions in each country. From the perspective of somebody accused of infringement, this may be seen to be a bit of a nightmare. Compared to the current situation where someone accused of infringement knows that they're going to be able to defend themselves in each country, the idea of perhaps an interlocutory injunction being granted before the full case has been heard on its merits, and as a result of that an injunction is granted which stops commercial activity across the whole of Europe, is something that can be quite scary. At the same time, it's not all bad news from the perspective of an accused infringer. It's got some advantages too. From the perspective of an accused infringer, if there is only a single patent covering the whole of Europe, that means there's only a single patent to attack. It means that it's quite simple to attack that patent by filing only a single invalidation action which covers the whole of Europe. It may also be advantageous if it turns out that the court in which you file that single invalidation action is one that isn't pro-patentee and perhaps is more in favour of an accused infringer. From the perspective of a patentee, that might be a nightmare. Well, whether you're looking at this from the perspective of being a patentee, someone who owns a patent, or someone accused of infringing a patent, we are expecting shortly to have a unitary patent and a unified patent court that will make some of these dreams and nightmares a reality. But before we go on to talk about the patent and the court itself, the first question we have to ask ourselves is, what is Europe? Well, from a patent perspective, we often think of Europe as being the European Patent Convention. Currently there are 38 countries which are party to the European Patent Convention, those that are highlighted in green on this map, and those are the countries where you can obtain patent protection through the filing of a European patent application. Now the Unitary Patent System and the associated court is not actually a vehicle of the European Patent Convention. It's going to be looked after and registered through the European Patent Office, but it's not actually set up by the European Patent Convention countries. The Unitary Patent is very much a vehicle of the European Union, and that's a smaller group of 27 countries, so all of whom are part of the European Patent Convention, but only 27 countries rather than the 38 of the European Patent Convention, who are grouped for all sorts of other political and economic reasons. Now, the European Union, which includes the countries which I've highlighted in green, which are the countries who have the euro as their currency, as well as a number of other countries, including the UK, highlighted in red, already have some intellectual property systems that apply across the whole of Europe. For example, there is the Community Trademark System and the Registered Community Design System, which applies across the whole of the European Union. But there hasn't until now been a community-wide or European Union-wide patent system, and that's where the Unitary Patent and the Unified Patent Court are intended to come in. Very much these are vehicles of the European Union, albeit ones that will be largely administered by the European Patent Office. So now we know what Europe is, I think it's worth talking a little bit about the history of patents in Europe. This is useful both because it will give some idea of how long it takes for developments to happen in European patent systems, and also because it will give you an idea of the types of protection which are currently available and which indeed will continue to be available once the unitary patent is an option. The unitary patent is going to be very much a further option instead of having the existing systems, but if you want to stick with the existing systems, they're still going to be very much available to you. Now the first slide in this section is a slightly unusual slide when I'm talking about patent protection in Europe, because it's got a picture of the Sydney Opera House, which clearly isn't in Europe. But the Sydney Opera House has the distinction of being opened in 1973, and in 1973 various countries in Europe signed up to the European Patent Convention. So what happened before the European Patent Convention, before 1973? Well, if you wanted patent protection in Europe before the European Patent Convention was signed, it was necessary for you to file a separate patent application in each country in which you required protection. And generally each application that you filed would have to be filed in the national language of the country in which protection was sought, and therefore you would have to prepare your translations up front. So for example, if you decided that you wanted patent protection in the UK and in France and in Germany, you would have to have an English version of your application and file that as a UK patent application at the UK Patent Office. You would have to make a translation into French and file that as a French patent application in the French Patent Office, and a further translation into German, which you would have to file as a German application at the German Patent Office. Each of those applications would then be independently searched and examined by the various patent offices in which they've been filed, and hopefully each office would eventually grant you a patent which would be a local or national patent, giving you protection in the country in which the patent office and the patent application was filed. Now you'll appreciate that this meant that you would have 3 potentially independent patents if you'd filed in the UK, France and Germany, and indeed in 1973 the law in each different country was slightly different, and so you may actually find that not only have you got 3 independent rights in 3 different countries, but they may actually have a very different scope of protection, and indeed in some cases you may find that the law allowed you to get protection in some countries but not others. Fortunately, that's no longer the case, and the law in all of the countries has been brought much more closely into harmony, and that's since the filing of the European Patent Convention. And therefore, if you filed separate applications in separate countries, you would hope that they would have very similar scope of protection and be granted in all countries, although there are some subtle differences still between the laws. You still have the option to file separate national applications in individual countries, and you can do that in virtually any country in Europe. And there may sometimes be very good reasons why you want to file national applications rather than filing, for example, a European patent application that I'll talk about in a minute. One reason is that if you're only filing in a small number of countries, certainly if you're only wanting protection in one or two countries, it is cheaper to file national applications rather than filing a European patent application. The other advantage in many cases of filing national applications is it tends to be much quicker to get a national application through to grant compared to a European application. So in the UK, for example, it's possible to get a patent application through to grant within a year to 18 months of filing the application, if that's what's required, whereas in Europe it's typically taking a minimum of 4 or 5 years to get patent protection. So anyway, that's the situation prior to 1973, where your only choice was to file separate national applications in each country where you required protection. And whilst that option is still available, the next development we had was in 1978. Now in 1978 not only was Greece released, but the first European patent applications were filed. Those first applications could cover only 8 countries, including the 3 major patenting countries in Europe of the UK, France and Germany. And as I explained earlier, you can now actually cover 38 countries by a European patent application. So there's been quite a lot of advance over the last 35 years. Compared to filing national applications, when you file a European application, you are just filing a single application, and that application can be filed in English, French or German. And therefore you generally don't have to file a translation at this stage, you're just filing it into one of those 3 languages. After the application has been filed, the European Patent Office will carry out a single search and a single examination, so it cuts down on the number of different searches and examinations that are the case if you file in multiple individual national countries. And hopefully, if you can overcome any objections that are raised, there will be granted a single European patent through a single grant procedure. However, once the European Patent Office has granted a European patent, it's then necessary to validate that patent in any countries in which you require protection. And we generally explain this as obtaining a bundle of national patents, because what you actually end up with, based on the granted European patent, is a bundle of national rights in each country where the patent has been validated. So, for example, if you were to validate your European patent in the UK and in France and in Germany, you actually end up with a national right in the UK, a separate national right in France, and a separate national right in Germany. And indeed, Germany will actually give that right a completely different number. So you'll have a different number for your right in Germany compared to the right in the UK or in France. Back in 1978, and for many years since then, it's generally been necessary to file a full translation of the granted European patent as part of that validation process. And so what that means is, whilst you've reduced the costs initially of filing translations, and you've reduced the number of different searches and examinations, thereby reducing costs, at the point of grant you still end up with separate national rights in each individual country, and you also have had the cost of translations. Now, the next real development coming on from 1978 occurred in the year 2000, when the principles of the London Agreement were agreed upon. And the idea under the London Agreement was to try and reduce the cost of translations. Essentially, the London Agreement means that for any country which has signed up to the London Agreement, it's possible to validate your European patent by at most filing a translation of the claims into the local language of the application without having to translate the rest of the description. Now this is all very well and good. However, of the 38 countries which are currently party to the European Patent Convention, only 18 have signed up to the London Agreement, which means that the majority of European countries are not covered by the London Agreement, and there's still a requirement for translations. Notably, Spain and Italy are two countries which haven't signed up to the London Agreement, and therefore if you require your European patent to be validated in Spain, you will still be required to file a full translation of the patent into Spanish, and similarly if you want protection in Italy, you will have to file a full translation into Italian. The other thing that's useful to note is despite the London Agreement being agreed upon in 2000, it didn't actually come into force until 2008, and this may give us some clue as to how quickly the new unitary patent system may come into being. Despite the London Agreement, you still end up with this bundle of national rights, however. And that means when it comes to enforcement of your patent, generally you have to enforce each patent in the national court covered by that patent. And therefore, even if you've had a European patent granted and you validate it in UK, France and Germany, and there is an infringement which occurs in UK and in France and in Germany, you will generally have to take separate national court proceedings in the UK Patent Office, in the UK court for infringement of the UK part of the European patent, in the French court for infringement of the French part of the patent, and in the German court for the German part of the patent. Now it's because of this really that the Unitary Patent and the Unified Patent Court system have come into being. So let's talk a little bit more about the Unitary Patent. How does it work? Well, the intention of the Unitary Patent is that instead of having this bundle of separate national rights, you will just have a single Unitary Patent, a single right. The idea is that it won't require translation into every single language, and it won't require separate maintenance through the payment of renewal fees in each individual country in which it covers. That's the idea. But how's it actually going to work? Well, we've already explained that the Unitary Patent is going to be a vehicle of the European Union, and therefore it can only cover European Union countries. That means that there are some notable countries in Europe, including Switzerland, Norway and perhaps Iceland, that cannot be covered by a Unitary Patent. It gets worse than that, because there are some countries within the European Union who have decided that they don't want to be part of the Unitary Patent system. In particular, Spain and Italy, two of the countries who haven't signed up to the London Agreement, are not going to be part of the Unitary Patent system. And therefore, if you are able to obtain a Unitary Patent, it won't give you protection in Spain or in Italy. Initially, all of the other countries of the European Union signed up to the Unitary Patent system, but more recently Poland have announced that they are not going to be part of the Unified Patent Court, and under the rules, if you are not part of the Unified Patent Court, then a Unitary Patent can't cover your country. Now we understand that Poland have some economic reasons for deciding that they don't want unitary patents to cover their country. In particular, we understand that there is a lot of manufacture that has been set up in Poland on the basis that that gives a European manufacturing base which currently isn't covered by very many European patents. And therefore, if there was a European patent for a product being manufactured in Poland, and that European patent, for example, covered Germany, if an injunction was granted in Germany, that would prevent the importation of the product, the sale or use of that product in Germany, but it wouldn't prevent the continued manufacture of that product in Poland. and therefore the manufacturer not manufacturing in a country that was actually covered by the patent would be able to continue the manufacture and export to other countries. Now Poland, we believe, have understood that if there is a unitary patent which covers Poland, that edge will be lost, because as soon as there is an infringement of that patent and an injunction granted, then that would cover the manufacture in Poland. And therefore there would be no good reason for people to set up their manufacturing in Poland compared to any other country in Europe. By Poland staying out of the unitary patent system, this means that they will be able to continue that manufacturing advantage not being covered by a patent. And it remains to be seen whether there are other countries in Europe which adopt a similar position to Poland and decide that they will not ratify the Unified Court Agreement and therefore will not be covered by a unitary patent. So, we know that there are only 27 countries in the European Union at present, and of those there are 3 countries which are not going to be covered by the unitary patent, meaning that a unitary patent could potentially cover up to 24 European Union countries. But how do you get one? Well, the simple answer to that is via the European Patent Office. As with any current European patent application, you will be able to obtain a unitary patent by filing a conventional European patent application at the European Patent Office and prosecuting it to grant as normal. The difference is going to occur once the European patent has granted, because then instead of having to validate that patent in each of the individual countries in which you require protection by taking steps before the national offices, you will instead have a 1-month period within which to select a unitary patent and inform the European Patent of this. You will need to pay any official validation fee to the European Patent Office for the unitary patent, and at least for the time being you will be required to file a full translation of the granted patent into one other European Union language. Now the requirement is that either the original patent or the translation must be in English, but then the other translation can be into any other language. So always for a granted unitary patent there will be an English language version and a version in one other language of the European Union. Now, if you decide to go for a unitary patent in this way, that will automatically give you protection for all of the countries covered by the unitary patent, and you then won't be able to validate the European patent as national validations in any of the countries covered by the unitary patent. However, as we've seen earlier, there will only be 24 or a maximum of 24 countries covered by the unitary patent, whereas currently the European patent system covers 38 countries. And therefore that's 14 countries which potentially you could normally protect with a European patent, but which wouldn't be covered by a unitary patent. And therefore you're going to be able to validate your European patent nationally in the way you currently do in any of those other countries which are not covered by the unitary patent. So what this means is if you prosecute an application at the European Patent Office in the usual manner, and it's granted after the unitary patent system comes into force, you will have a choice. You will either be able to validate the patent nationally in any of the 38 countries in which you require protection, much as you do now, or you will be able to select a unitary patent, and that will be one right which covers all of the countries covered by the unitary patent system, with the option then of doing additional validations in any of the other countries. Now what's quite interesting, I mentioned earlier that there's a requirement to file a full translation into another language of the European Union. You might decide that you want a unitary patent, but you also want to validate that European patent in Spain, and as we've seen earlier that means you will need a Spanish translation. At the moment, as I understand the rules, there is no limitation as to the language of the translation, providing it's another European Union language. And therefore, if you are validating in Spain and obtaining a translation into Spanish, I believe that you should be able to file that Spanish translation with the European Patent Office as the translation of your European patent application. As I say, the system is going to be available for any European patents which are granted after the Unitary Patent System comes into force, and therefore it may well be that applications that you file now, or indeed have recently filed and remain pending, are ones that could be granted and formed into a Unitary Patent in due course. The big question is, how much is this going to cost? How much is it going to cost to obtain a Unitary Patent? And the short answer is, at the moment, we don't know. But please do have a look at our website, which is www.reddie.co.uk, because as soon as we get any information, we'll be making sure that we put it up there. When it comes to costs, what we do know is that with conventional European patents which are validated in a number of countries, it is necessary to pay an annual renewal fee in respect of each of that bundle of patents. If you have a Unitary Patent, you will instead have to pay a single annual renewal fee to the European Patent Office to cover that Unitary Patent, rather than having to pay separate renewal fees to each country. The expectation is that that renewal fee is going to be around about equivalent to 5 national renewal fees, and that's on the basis that very often European patents are validated in 5 countries, and therefore there are 5 national renewal fees. However, the renewal fees do vary greatly, and so it's going to be interesting to see whether the eventual cost of renewal fees is higher or lower than what we would consider the average. It's also possible that there may be some small entity allowances, therefore if you are a small company who owns a patent, the renewal fees may be lower. There will be validation fees payable to the EPO, there will be attorney fees. My guess is that the validation and attorney fees will be lower than the current validation fees for a large number of countries. There will also be translation costs. If at the moment you validate European patents in countries which are party to the London Agreement, there is no requirement to translate the main body of the description. Therefore, your translation costs in those countries can be low. Whereas we've seen earlier, for a Unitary Patent you are going to have to file a full translation of the entire specification, and therefore for many people this may actually increase the translation costs. Overall, my guess is that if you are used to filing a European application and validating this in 20 or more countries, it's certainly going to be cheaper to obtain a Unitary Patent. If, on the other hand, you normally file a European patent application, and when this is granted you validate it in only 2 or 3 countries, it's probably going to be cheaper to continue with that practice and not use the Unitary Patent System. If you are typically filing and validating in 5 or 6 countries, then it's going to be pretty close in my view as to whether the Unitary Patent System is going to be cheaper or the conventional national validations is going to be cheaper, and you've then got to balance whether you want to pay potentially a little bit of extra money to get protection in many more countries, or whether you want to stick with a smaller number of countries as you currently do. As I mentioned earlier, you're not forced to take the Unitary Patent route. You've still got the option to file national patent applications or to file a European application, and when that proceeds to grant, to validate that in individual countries. But cost isn't the only issue which may determine whether you want to file and obtain a Unitary Patent or national validations, because we also have the Unified Patent Court. Now, as you would expect, the Unified Patent Court is going to be able to hear matters of infringement, matters of revocation, and it's going to be able to award injunctions and damages where there are findings of infringement, and also revoke a patent where the patent is found invalid. That's exactly what you would expect from a court. But what sort of cases can the court actually hear? In particular, what sort of patents does it have jurisdiction over? Well, the Unified Court is going to have exclusive jurisdiction for unitary patents. So if you obtain a unitary patent, the only country where you could enforce that patent, the only country where you could sue, or the only court where you could sue for infringement, and indeed the only court where people could claim that your patent was invalid, would be the Unified Patent Court. At the other extreme, if you have a national patent, so for example if you have obtained a UK patent via the UK Patent Office, the Unified Patent Court will have no jurisdiction over that case. And therefore if you want to launch an infringement action for a UK patent, that would have to be done before the UK court. That's quite simple and quite clear. You'll be able to tell whether you've got a unitary patent or a national patent, and therefore whether the court in which cases are held will be the national court or the unified central court. However, things become a little bit muddled for European patents, for the conventional national validations of a European patent, including both those patents which have already been granted and those granted in the future. Essentially, the default position is that for all of those national validations of a European patent, even those that have been granted in the past, the Unified Patent Court will have jurisdiction. And therefore the default position is that infringement actions for those national validations and revocation actions launched against those national validations will be before the Unified Court. However, there is a transitional provision, and the transitional provision says that for the first 7 years after the Unified Court comes into being, proprietors of European patents and indeed of applications, including those that have already been granted, already been filed, and those that will be filed or granted within that 7-year period, will have the option to opt out of the Unified Court system. And that means that for those cases, any infringement or revocation action, at least initially, would have to be brought before the national courts, as is the current case. Now, many people think this is quite attractive because they don't like the idea of their patents being revoked centrally by a new, untried and untested court, and therefore I think an awful lot of people are going to want to opt out for their existing applications and patents and those filed and granted within 7 years of the Unified Court system coming into being. A couple of little additional bits here. You may think, well, perhaps I won't worry about opting out until I actually want to enforce my European patent. The trouble with that is, if somebody else were to launch a revocation action against that patent, and you haven't opted out, they will be able to launch that action before the Unified Patent Court, and they'll be able to launch that as a centralised action against all the national validations. Once an action has been begun in the Unified Court, it's no longer possible to opt out. So in other words, you must opt out before you or anybody else takes any action with respect to your patent before the Central Court. And essentially that means you've got to opt out as soon as you can. Another issue is how much is it going to cost to opt out and what's going to be the procedure. Answer at the moment, we simply don't know. There is almost certainly going to be an official fee for opting out because the European Patent Office have got to create an entry onto a register to show that you've opted out, but we don't know how that fee is going to be set or how it's going to be based. Whether, for example, it's going to be on each individual national validation, or whether it's going to be on each patent, or even whether it's going to be, say, a fixed fee for all patents owned by a particular proprietor. I suspect that the latter is not going to be the case. That would be far too easy. Finally, with the transitional provisions, you may be thinking, I'm not sure if I want to opt out because I might actually want to take advantage of a centralised court to obtain a pan-European injunction if there's infringement. Well, that's not a problem. If you've opted out, so the default position then is going to be that all actions are held in national courts, you will have the option to opt in. So when you find an infringer who's infringing in multiple European countries, you will have the opportunity to opt in before you launch that action. The one downside is once you've opted in, you can't then opt out again. So it's a kind of a one-way door. Once you've decided that there's an infringement and you want to make use of the unified court, you can't then change your mind and go back to national court proceedings. You're stuck with the unified court. Okay, enough of the different cases that the court can hear and how you can get out of the court system. I'll briefly talk about where the court is structured. One important thing to remember is there is a single unified court. There is one court with one set of procedures, and therefore the decision should be the same whichever courtroom you end up being in. However, the court is structured to have a central division, and the central division is going to have 3 seats. The first seat is going to be the seat in Paris, and that's going to handle various subject matters of case, including physics and electronics cases. The second seat is going to be in Munich, and in Munich they will handle a different set of subject matters, including, for example, the mechanical cases. And the third and final of the central seats is in London, and in London they're going to handle chemical, metallurgy and human necessities cases. So those are the 3 central division seats, and the subject matter is going to determine which of those 3 seats a case will be held in. But in addition to the 3 central seats, any individual country is able to set up a local division court, or any group of countries is able to set up a regional division court. So for example, the Benelux countries, Belgium, Netherlands and Luxembourg, may well decide to set up a regional court covering those 3 countries. The composition of the judges in the local courts is going to be slightly different from the composition of judges in the central division. They will still have at least one judge coming from the same central pool from which all of the judges in the central division courts are based. And as I said earlier, they will all work in accordance with the same procedure, and therefore the decisions broadly should be similar. However, there are going to be some differences between the courts, and that may give a certain element of forum shopping. One of the differences is going to be languages, and there's lots of provisions about language and lots of alternatives. But broadly speaking, if your case happens to be one heard at the central division, then the language of the proceedings will be the language in which the patent was granted, English, French or German. Whereas if you end up having an action which is brought before a local division court, then the language of those proceedings is likely to be the language of the country in which the court is based. So for example, if you ended up bringing an infringement action before a local division court based in Portugal, the expectation is that those proceedings will be heard in Portuguese. So which court do you have to bring the proceedings in? Well, it depends what type of proceedings they are. Assuming that the first initiation of the proceedings is the initiation of an infringement action. So let me say I'm going to sue you for infringement of my patent. The first thing that I would have to do is look to determine which country or countries the infringement was taking place in. That will give me sort of a first list of countries. I would then have to determine which country or countries you as the accused infringer are resident in, or where you have a place of business. That will give me a further list of countries. Now when I look through that list of countries, the first thing I need to do is to see whether any of those countries have a local or regional division court. And if they do, that's the court where I should take action. Now what this does mean is that you may have infringement in multiple countries, and therefore you could choose any one of those countries to take action, provided they have a local or regional court. But it may be that you are forced into taking the action at a local court because it's the only local court which exists in a country where the infringement is taking place. If there is no local or regional division court in any of those countries on those lists, then the first action the infringement action would need to be filed at the central division, so the seat in Paris or the seat in Munich or the seat in London, depending upon the subject matter of the case. So let's give a positive example. Let me assume that there is only infringement in Portugal and the infringer is resident in Portugal. Under those circumstances, if there is a local division court or a regional division court covering Portugal, that's where I would have to initiate the infringement action. However, if there was no local or regional division court in Portugal, then I would have to initiate the action at the central division based on the subject matter of the case. Things are perhaps a little simpler if the first action is a revocation action. So the first action is you seeking to revoke my patent. In that case, you would have to initiate that action at the central division, either in Paris or in Munich or in London, depending upon the subject matter of my patent. Things can get a little bit more complicated when it comes to counterclaims. So a counterclaim for invalidity, and this occurs if I've sued you for infringement and you are counterclaiming to say that my patent is invalid. If you're doing that counterclaim, you would have to file that counterclaim at the same division as the initial proceedings, so in the same division that I launched my infringement action. However, that court can then decide either to hear both the infringement and validity actions together, so much in the same way as currently the case in patent court proceedings in the UK, where the judge will hear at the same time the infringement and the validity proceedings, or that local division or regional division could decide to bifurcate the proceedings by separating out the revocation action and sending the revocation action to the central division based on the subject matter. And if the local or regional division were to bifurcate the proceedings and hand off the revocation to the central division, the local or regional division court could then decide either to suspend the infringement proceedings until the revocation action has been determined, or could decide to continue the infringement proceedings in parallel and potentially make a decision on infringement before a decision has been made on revocation. Just to confuse matters even more, because of the language requirements, so far as I can see, it's perfectly possible that, say, the Portuguese court will continue to hear infringement proceedings in Portuguese, whereas the revocation may be heard in, for example, English, if English was the language of the patent, in the Paris court, assuming it was, say, an electronics case, and therefore there's all sorts of confusions with different interpretations based on different languages of the proceedings. Time will tell. If you're counterclaiming for infringement, so this is a circumstance where you first took an action to say that my patent was invalid and I decide to counterclaim for infringement, I can essentially file that infringement action in any court that I would normally have filed the infringement action. So a little simpler there, though still the possibility of having bifurcated proceedings and different languages. So, with all of that discussion about the Unified Patent Court, what are its pros, what are its cons? Well, it's clearly got an advantage for many people that there is a single action. If you're a patentee and you are successful, it's got an advantage that there is a single injunction covering all of the countries in Europe. You don't have to take separate actions and obtain separate injunctions in separate countries. It's also very much expected that the procedure is going to be very simple. The procedure is expected to be largely a written procedure, ending probably in a one-day hearing. So it's much simpler than many existing patent cases in Europe. At the same time, some of these advantages, as we saw earlier, could be seen as disadvantages. If you were the patent owner and you were unsuccessful, you might find that there was a single revocation which invalidated your patent across the whole of Europe. And in my view, that's going to be the biggest concern with the Unified Patent Court for many existing patent owners. There is only a single forum. You don't have the opportunities to go for country where there is more discovery, such as the UK, rather than a country where there is less discovery, such as Germany. One where there is bifurcated proceedings, such as Germany, as opposed to one where all the proceedings are handled together, such as in the UK. Essentially, there is only a single forum, less forum shopping. The simple procedure has its advantages, but it also has its disadvantages. I think most people who have been involved in patent cases will be aware that the procedure can be very complicated and the hearings are often quite long and detailed and involved, and the thought of having a hearing which lasts only a day to determine right across Europe whether a patent is valid and infringed is something which worries many people. And as to quality and speed, well, the short answer is we really don't know at the moment. We don't know what the quality is going to be of the new system, largely because it's untried and untested, and we don't know how quick it's going to be. Now, the final issue that I'm going to address is timing. The original hope was that the Unified Patent Court was going to come in early in 2014 and that the unitary patents would be granted 3 months after the Unified Court was in place. It seems much more likely that it's going to be probably late 2015 at the earliest before the Unified Court system comes into place, and 3 months after that before the first unitary patents are granted, and it may well be 2016, 2017 or even later. Part of the reason for this is that for the unified court system to come into place, it needs to be ratified by 13 of the 27 European Union countries. We already know that some of the European countries are not going to ratify the court agreement, so 13 actually represents the majority of the remaining countries. Ratification must be signed by the UK and by France and by Germany as the 3 countries in Europe where most patents are validated. At the moment, there is an awful lot to be done before the court can be put into place, and we're certainly aware that, or expecting that, the UK government is going to delay ratification until the court system is in place. And realistically, the expectation is that's going to be 2015 before the court system's in place, and therefore that's the earliest that the UK are going to ratify the Unified Court Agreement. It may be that there are some other countries who delay, and so it may take some time until we get 13 countries who have ratified the agreement. If we remember before, it was 5 years from the European Patent Convention being signed before it came into force, and the London Agreement took from 2000 to 2008. So with the unitary patent documents being finally agreed upon late in 2012, it may be that 2015 is a little bit hopeful. There's also the possibility that there are 1 or 2 more hurdles in the way. Italy and Spain not only decided that they didn't want to be part of the unitary patent system, but they also filed various legal objections to the system which would have prevented it from coming into force at all. Many of those objections have been overturned, although there are 2, I believe, objections still outstanding, and it's possible that these or some other hurdles could actually prevent the unitary patent system and the Unified Patent Court coming into place at all. My personal view is that we've got this far down the line that I think it is now going to happen. It's really just a question of when. So with that, it is largely the end of my introduction to the unitary patent system, including the Unified Patent Court. My view at the moment is that there will be some companies who are used to validating in lots and lots of countries who will continue to validate in lots and lots of countries to obtain individual patents via the normal European system rather than unitary patents, because they want to make sure they stay outside the Unified Court system. There will be some other companies who are used to just validating their patents in 2, 3, possibly 4 countries, who will decide that it's best to continue with that practice because that's the cheapest way to obtain patent protection, and also because this avoids the Unified Court system. And then there will be a lot of other companies, quite possibly small and medium-sized enterprises, who will decide that the unified system, the Unitary Patent, is a much better option because it allows them to get protection across Europe more cheaply. However, there are many things that have still got to be decided, and so please continue to look at our website, and if you've got any more questions, contact me or Julie, and we'll be happy to try and answer those questions and give you more advice as the system develops. Thank you very much for listening.